Oh my, nursing home contracts, what to avoid. That's a great question, folks. It was a conversation that I had in a family meeting with clients earlier today. Folks, I am elder law care attorney Patrick Kelleher, author of How to Avoid a Four-Headed Monster of Estate Planning and Elder Law on Amazon. Strongly recommend pick up a copy of my book on Amazon, Patrick Kelleher, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law, because you will learn a lot. You'll learn how to protect yourself and your loved ones. Folks, our subscriber to our YouTube channel sent a question in today. Let's see. Patrick, nursing home contracts, what to look out for? Well, I'm going to tell you what to look out for, folks. When you're reviewing a nursing home contract for a loved one, and this is a conversation and advice I gave the folks earlier today, the family assembled, they came in today about their dear parent who is now transitioning from hospital to rehab to the nursing home, just like my late dad. And so we see this very common. And I caution the clients, I said, when your parent is being admitted to a facility, like a skilled nursing facility, they typically going to give you a big contract, an admissions agreement. You might be tired, you might be exhausted. It could be at the end of the day, you've worked all day, taking care of family, and you just look at that agreement and you take the pen out. You're happy that your loved one's going to have a warm bed to sleep in and a roof over their head with medical care, and you just sign it. Caution, hold the phone right there, folks, because we had cases where family members have done that, and then a year or two later, after their loved one has passed away, the nursing home bookkeepers, accountants are doing an audit on their books, accounts receivable, and they're like, oh, there was a month or two while this resident, former patient, was looking to receive Medicaid benefits to pay for their nursing home care, and there's a gap in coverage. There was a gap in payment. So who are we going to go after legally to make this payment of $14,000 or more? And typically they're going to go after the person who signed that admissions agreement. So folks, this is really, really important. So if you're admitting your loved one to a facility, and this is the advice I gave folks earlier. Number one, if your loved one can still sign themselves, if they still have the testamentary capacity and they can pick up a pen legally, and they do not have severe dementia or moderate dementia, if they still have the cognitive capacity and they have proper testamentary capacity to know what they're signing, they should sign themselves, from my experience. However, a lot of times they are unable because of their medical frailty, their diminished capacity, their vulnerability. They're not able to sign themselves. So they're looking to you, a spouse, a child, a niece or nephew, a trusted loved family member, to sign for them. And this is my second piece of advice right here, folks. Do not sign personally ever. Do not sign personally ever. If you do have to sign, you want to sign as attorney in fact under the durable power of attorney that hopefully your loved one took responsibility and created. And I just created another video on the importance of creating that durable power of attorney to give your attorney in fact legal authority to manage all your financial affairs for you, including signing admissions agreements to a skilled nursing facility. And when you sign Bill and Mary, do not sign personally, you put your designation, your office as the attorney in fact, AIF for abbreviation, attorney in fact, on that. That's what you need to do, folks. Number one, preferably have your loved one sign. Number two, if they're unable to sign, then you sign under your office as a durable power of attorney, attorney in fact, agent, helper for your loved one. That way, if you do get sued, you're in a position, your defense is, I cannot get sued personally because I was wearing my hat, my durable power of attorney, attorney in fact hat, in that legal capacity. You cannot sue me personally, okay? Number three, folks, what you want to be on the lookout for is language guaranteeing payment and warrantying payment. Oftentimes, it's similar to if you go to a doctor's office and they're like, oh, can we have your medical insurance card? But you're going to sign this paperwork saying that if your medical insurance doesn't pay or cover, if they decline, you're going to pay personally. It's similar to that. But they might have it buried on page 15 or 25 of a lengthy agreement, and it's the middle of the night and you're signing this. So you want your elder law attorney to review it, is my recommendation, my advice. And you want to strike out any guarantee language or warranty language. You want to strike that out, is my advice, and have your elder law attorney review that. Because there's certain laws that protect our seniors, the Nursing Home Reform Act, as well as the Patient Bill of Rights. They shouldn't have that language in there if it's too aggressive or too overreaching. But from our experience in the elder law industry, these facilities still put that language in the four corners of that admission agreement. So it is in your best interest to follow my advice here in this video, my recommendations, and work with your experienced elder law attorney to make sure you cross the T's, dot the I's. So folks, there you have it. If you found today's educational video helpful, please share it with others. Please share. Our YouTube channel is growing. Share it with others and click the subscribe button. Click that notification bell because we will keep you updated with other educational elder law videos as well. Also follow us on other social media platforms, on Facebook and on TikTok as well. So, and of course, follow us on our YouTube channel and our website, elderlawcare.com. Folks, Patrick Kelleher coming to you from Elder Law Care. Thank you.